Good afternoon, class. I hope you are doing well and are settled in for today's discussion on protected speech. This is Communication 120, Laws on Communication and Mass Media. For today, we will begin our lecture on protected speech. And this is our first time tackling cases. So I hope you will look closely at the more important details of the cases rather than on the full text of it. Okay? So kung ano lang yung importante sa atin. First off, we must take note that freedom of speech is very important. It would seem to be the foundation of every other right. Freedom of speech is not just about your or our right to express ourselves, but also it involves the right for others to be heard. What's important is that there is an exchange of ideas. Because with the exchange of ideas comes the possibility for change. I mean, imagine nyo, nung panahon ng Kastila at wala tayong um, discussion o nalaman man lang tungkol sa Age of Enlightenment sa Europa, di hanggang ngayon, Age of Darkness pa rin tayo. So, yung konsepto pa lang na nalaman mo, it allows you to form additional thoughts of your own. And beyond thought, there would come action. In the case of Gonzalez versus Comelec, this is a 1969 case. The court right off the bat mentioned that freedom of speech occupies a preferred position in the hierarchy of civil liberties. Ganun kabigat ang trato dito. And so for our discussion today, these would be our guide questions actually for today and the next session. First, what are the aspects of freedom of the press as related to freedom of speech? Kasi klaro yan dapat malinaw yung elemento sa atin. Second, what is symbolic speech? If we think of speech as in literally what's spoken or what's written, there can also be expression or speech that is in the form of conduct. So, yung pagsusuot ng damit, pagkukulay ng buhok, etc. That's also expression. That means something, no? Now, and also how the freedom of speech is related to other rights such as the freedom of assembly, academic freedom, electoral process, freedom of religion. That's for our next session. And just two important points about location and form. So we'll be talking about that in this entire module. But for now, we'll do the first two questions. What are the aspects of freedom of speech of the press, and what is symbolic speech? Right off the bat, I will tell you that there are four aspects of freedom of speech: prior restraint, subsequent punishment, access to information, and freedom of circulation. Okay, let's first take on the case of Neer versus Minnesota. In this case, Neer is the sole proprietor and owner of a local newspaper called The Saturday Press. And he is being sued by the Minnesota local government. Okay, what happened was, Neer published an article or a series of articles against government officials na critical. He says that there was a Jewish gangster in Minneapolis who was into gambling, bootlegging, racketeering in their area. And the law enforcement officials were not doing anything about it. The chief of police uh, was in gross neglect of duty, and sinabi pa niya, kasapakat yata to eh. There are illicit relations. Yung district attorney or yung county attorney, so yung parang government lawyer, he knew about the existing conditions or the existing incidents, but he was not doing anything about it, same as the mayor. In fact, the mayor should be sued for inefficiency, and because it's the mayor who should rid the county of crime, he is in dereliction of duty. So, mabigat, no, ang mga allegations nitong The Sunday Press. And in fact, there was an assassination attempt on one of the original defendants, or or the one of the editors. So, dun sa site siya ng Saturday Press. Pagkatapos na publish, nagkaroon daw ng assassination attempt by the gangsters. Okay, by the gangsters. Kasi ganun kabigat yung mga articles na na-publish. The case involved both the application of the law and the constitutionality of the law. So, the argument of NIR and the Saturday Press was that when it was applied to them, it was applied to them incorrectly. Okay? The interpretation of the law is incorrect. And what is the law? Okay. So in the laws of Minnesota, there is the public abatement of nuisance. When we say public abatement of nuisance, pinapatigil mo yung isang magulo na or panggulo sa publiko. At there's two parts to this provision. First, a public nuisance is any obscene, lewd, and lascivious newspaper, magazine, or other periodical, or a malicious, scandalous, and defamatory newspaper, magazine, or other periodical. Okay. So, ang pinangtira dito kina NIR and the Saturday Press was the public nuisance. Huwag kang magulo. Law. So, clearly, it is suppression. Diba? Kailangan mong patigilan na isang public nuisance. One example I can give you off the bat would be nagvi-videoke kapag Sunday. No? The government, through your local barangay, usually they pass ordinances about loud singing kapag Sunday kasi nagaano nga naman. That's a public nuisance na nakakasira ng peace and order. In this case, they said that similar to nagbibidyoke, kailangan patahimikin yung dyaryo. And so how did the court rule? Actually, in the lower courts, hindi ito masyadong pinansin yung constitutionality, no? At sinabi na lang na as applied, kailangang matigil or nanalo, kumbaga yung Minnesota government. So, nagkaroon ng injunction. Nung kinwestiyon nila yung constitutionality and it went up to the Supreme Court, the court ruled that the statute, the provision, letter B, which provided for malicious, scandalous, and defamatory newspaper, magazine, or other periodical, that part is clearly in an infringement of the liberty of the press as guaranteed by law. And even without looking at the truth of the charges as published by the Saturday Press, the law is unconstitutional. So, hindi nasisilipin pa yung as applied. On the face of the law itself, it's unconstitutional. And so, how did it rule? Why did it rule that way? So, first, the court looked at what was the means. So, papaano ba inaatake yung public nuisance, pinapatigil. And clearly, that is suppression or prior restraint. It's not punishment. pinapatigil mo mag-imprenta yung dyaryo. And in fact, kunyari, gumulong na yung kaso. Kapag na-issuehan ng injunction, so, kailangan mapatigil no? Susundin mo kaagad yon. Kapag na-issuehan ng injunction o kaya, ang injunction, it's you stop, prohibition, you stop muna for the moment kung anong nangyayari. So, stop publication. That, if you continue publication, which is an exercise of your right to free speech, that would be contempt of court. And this is regardless of what you will publish. Kasi yung public nuisance, you have to stop writing, publishing altogether. Balik tayo sa example na nagbi-videoke, regardless of kung anong kinakanta or kung sinong kumakanta, sintonado man o hindi, ititigil mo yan. Kahit bumalik si Lea Salonga sa videoke ng alas 9 ng gabi ng linggo, pipigilan pa rin yan. And therefore, the court said, that's improper. Outright na suppression or prior restraint. Effectively, that would be a censorship. Now, the court, of course, looked into this matter of libel and said that libel as a crime is allowed under the law, but then it is punishment after the publication, not before the publication. Second, on the part of truth, that's a different thing altogether. Yung suggestion ng Minnesota na, what if during the public abatement proceedings, magkaroon ng hearing to ascertain the truth para alam po natin kung malicious ba to, scandalous, defamatory, ganyan. Sabi pa rin ng court, well, that's still censorship or prior restraint kasi truth, in fact, well, later on we'll talk about truth, how it is used or how it is appreciated in libel. Truth, in fact, will just be yung ascertainment of truth, it will just be an additional burden on the publication. Mapipigilan mo yung publication to speak for itself. In this case, there is a heavy reliance or respect for the role of media as part or promoter of public debate. Hindi ng skandalo So, public debate. If more people know what's happening in government, then all the better. Whether that's true or false, saka na natin harapin yon. Kung mali at malicious, then magkasuhan na ng libel. Pero you cannot, right off the bat, pigilan yung dyaryo na mag-publish. For the case of New York Times versus US, let's have a video from a YouTube site.
There are virtually no constitutional absolutes, but the First Amendment's prohibition against prior restraints of the press comes close to being one. Are prior restraints ever permissible? The splintered United States Supreme Court addressed this issue in New York Times versus United States. Daniel Ellsberg helped author a top-secret government study, informally called the Pentagon Papers, that contained embarrassing information about the government's involvement in the ongoing Vietnam War. In 1971, he leaked portions of the report to the New York Times and Washington Post. After the newspapers published articles based on the leaked portions and indicated more articles were forthcoming, the Justice Department filed lawsuits in federal district courts in New York and Washington, D.C., seeking injunctions against publication of further articles based on certain portions of the leaked material. The government offered no proof that future articles would cause a break in diplomatic relations with any country or a new military conflict or would compromise military or intelligence operations. Rather, the government merely tried to prove that the articles would interfere with the State Department's negotiations concerning the war's end and generally embarrass its diplomatic efforts. The two district courts denied preliminary injunctions, and the government appealed. The D.C. Circuit affirmed the district court's order, but the Second Circuit entered a temporary restraining order and remanded to the district court for further proceedings. The New York Times successfully petitioned the United States Supreme Court to review the case before judgment in the Second Circuit, while the United States successfully petitioned the court to review the D.C. Circuit's judgment. The Supreme Court consolidated the cases.
Okay, for that case also, you can look at other at other sources, including movies. There is a movie, The Post, which dramatizes what happened in the case of a Washington Post, starring Meryl Streep. Now, let's go domestic in the case of Burgos versus Chief of Staff. In this case, which was decided in 1984, um, this actually is a post-martial law case. However, of course, during this time, President Marcos was still in power and still exercising the same authority, same powers under, during the entire dictatorship, okay? Ng martial law, pero dictator pa rin siya. In this case, there were two newspapers who were forcibly closed, okay? There were warrants issued for the premises for the offices of Metropolitan Mail and We Forum, tinatawag nating Mosquito Press. And the government wanted to search and seize items alleged to have been used in subversive activities. When we say subversive, during this time, under the Anti-Subversion Law, RA 1700, membership in the Communist Party of the Philippines and NPA were prohibited. So, that's subversive. Ngayon, hindi na. Lifted na yon. Now, medyo delikado, no? Komplikado nung panahon na yon. Mabanggit lang to o ma-mention yung tungkol sa CPP or NPA, which was quite important, no? And very real as part of our history, dahil dito lumaki ang kanilang membership ng panahon ng martial law. Mahirapan ka kung dyaryo ka nun at hindi mo sila i-cover. Now, in this case, the issues would largely revolve around search and seizure, the lack of probable cause for the search and seizure. Also, the fruit of the poisonous tree. Kumbaga, if you search somewhere without authority, everything that you search, everything that was the fruit of the tree would be poisoned. So if the search warrant is wrong or illegally obtained or void, hindi na pwede yung mga nakuha mo. So it would be, seizure of the item would be impermissible. Okay? So maraming mga discussion doon, pero what's important for us would be this part about search, seizure, and closure. So after the seizure of the item, take note that these are the printing equipment. They also took away, I think, mga sasakyan. Basta yung mga gamit na nagalahat publish. Clearly, they could no longer function. They could no longer publish. Likewise, also, they padlocked the building. Okay? So, sinara ang buong bentahan. Kaya, klaro na hindi makakapag-publish. Okay? Therefore, this closure, this is the only thing that's important. It's just one paragraph in the article, in the decision. This closure is in the nature of a previous restraint or prior restraint or censorship, which is abhorrent to the freedom of the press. It denies the rights of the petitioner to free press, free expression, and it's contrary to our democratic framework. Ganun yung pagkaka-phrase nila. In this case, there was also an issue about sequestration. Sabi ng gobyerno, through the chief of staff, sabi nila, sinequester na namin to under a particular law. Ngayon, mukhang nagkalabuan, dininay ni Marcos himself na ni-request niya yung military authorities to sequester the properties. Kaya, yung closure, whether under, supposedly under yung virtue of the search warrant, tapos search, seizure, and closure, or under virtue of sequestration, still on the basis of subversive activities, ay hindi tenable. Which is why it's really important to look at the political context of what's happening around us. Kasi some things might not necessarily have the legal authority, pero nevertheless, it has the political complexion. Kaya nangingibabaw yung pananaw ng mas malakas or in power. Now let's go to movies. In the case of Friedman versus Maryland, there was a film called Revenge at Daybreak. Huh? The problem here is more of procedural. So, pinalabas na yung pelikula sa Baltimore nang hindi mo na sinasubmit sa State Board of Censors, which was required by law at that time. Sabi naman ng state, well, nung tinanong o sige, kung isabit ba sa inyo, meron bang mababiolate yan? Sige nga. Later on, may pag-amin naman sila, wala naman. It does not violate any of the standards and would have received a license if it had been submitted. Pero still, sabi niya, hindi, kailangan sinabit mo kasi. Bakit mo kasi hindi sinabit? So what happened? The court ruled that the filmmaker were in the wrong. The Court of Appeal said, medyo mali nga kayo. At nung umakyat sa Supreme Court, dito lang nabaliktad. Okay. Now why? This was actually a question of constitutionality. So, the statute or the law in question was the one that required the submission of all movies and pictures to the State Board of Censors. Ang problema lang, there is no time limit for the completion or for the action. So, hindi mo malalaman kung kailan sasagot yung board. Kapag disapproved o kaya may pinatatanggal, iyon, automatic na sasabihan ka na, sige, ayusin mo to, tanggalin mo to. They would have a right of appeal, generally under specific rules period. Pero ang problema, there was no confirmation or clear point about the time frame. So, pwedeng ma-delay. Paano kung hindi siya i-disapprove? There's no period for that. Actually, there's also no period for approval. There's no period for approval. There's no period for disapproval. Ang may period lang, yung kapag may dinisapprove tapos nag-apela ka, nag-resubmit ka, doon may specified period. Kaya, dito nga dito sa kasong to, may ni-raise na example. May isa daw nangyari na yung determination nung yes, no, approve, or what, it took 4 months. Tapos nung inakyat pa sa korte, umabot pa ng dagdag 6 months. So, parang sobra namang delay ito. Ngayon, ang tanong, is this prior restraint? The court here held that technically, the state can regulate films and they can priorly restrain. However, it must be subject to precise rules governing any other particular method of expression. Okay? Kailangan malinaw kung paano, kung kailan, kung saan mo ipapa-regulate yung film. And so in this case, the court just held that una, babalik na rin natin yung presumption, okay? Kasi kapag nag-submit ka ng film, parang ang presumption nandun sa filmmaker na valid or maganda or pasado dun sa standards yung film mo. Balik na rin natin. First, you assume that the film is okay and it is up to the board. The board has the burden to prove that the film is unprotected. So, yung censor, siya yung magsasabi kung oo, hindi. Otherwise, it's presumed admissible or okay. Second, although the state can require prior or advanced submission of the films so that the procedure is effective, these requirements should be administered na in such a sense that it's not just the censor who will say so. Dapat merong appeals mechanism kung saan may ibang tao or third party who can hear also the side of the person or institution being censored. So, pagpunta mo sa board, sinensor ka o hindi siya yung final say. Pwede kang umapela or umakyat. And lastly, there should be a specified period of time. Hindi yung nakanganga ka, nakatunganga, habang pinag-iisipan ng censor kung anong gagawin. Otherwise, talagang it would constitute delay. Okay? So, ang importante dito, yes, you can censor, or you can screen, but you cannot effectively stymie the screening of films which are to be presumed protected speech right off the bat. The next case, Ayer Productions versus Judge Capulong, is also about a movie. And let's see that movie.
I am returning to the Philippines because my country is now in crisis. I have my bulletproof vest, hoping that would be some kind of a protection. But if they hit me in the head, there's nothing we can do there. In a matter of 3-4 minutes, it could be all over, you know. And I may not be able to talk to you again after this. So this is the danger.
Ninoy is coming.
I warned him not to come back when I saw him in New York 3 months ago. He wants to grab power.
Hi, Mr. Morning.
Mr. O'Neill,
Yes.
telephone call for you. New York, wait here.
Hello.
Tony?
You gotta stop in Honduras on the way home. The United States is holding military maneuvers there to shake up the Sandinistas.
Alex, Marcos and his wife and their goon squads, they have a stranglehold here. All with American support, especially Reagan. Now, Aquino is about to land, and maybe he's gonna say enough is enough. For God's sake, Alex, this guy could start a revolution.
Tony, cover Aquino's arrival, then get back here. Just don't forget to stop in Honduras.
Alex! God damn! Come on.
So let's continue the discussion. This case is about this movie, A Dangerous Life, pero originally it was titled the 4-Day Revolution. So, this is an Australian film which was endorsed already. So, it was proposed, because this is an Australian company, it was proposed to be done, of course, in the Philippines. So, with permission. Um, this was already discussed, no, with a local movie producer, etc. And this was also consulted with government agencies and with General Ramos and Senator Juan Ponce Enrile, who had played major roles in the events that were proposed to be filmed. Ang kwento kasi nito, merong Australian journalist na may Pilipinang jowa, may girlfriend, na na ano to, nagko-cover ng events nung the 4-Day Revolution. And so, it would be, the historical events would be a backdrop to their own stories. How their love life will develop, paano yung relasyon pa nila, or yung coordination with local newspapermen, etc. Medyo fictitious, pero docudrama, kumbaga, ang datingan yan. Fictitious, pero may bahid ng katotohanan. And among those who were sought, those public officials who were sought to be portrayed, was Enrile, the ever-alive Enrile. Now, Enrile questioned the showing of this film, although remember that he was consulted. He said that he will not approve of the use, appropriation, the production, exhibition of his name or picture of or any member of his family in any cinema, etc., etc., because it will be a violation of his right to privacy. Okay, at the start, the petitioner, so yung Air Productions, yung gumawa ng pelikula, pumayag. And the name of Enrile, it was deleted from the script. Tapos, yung isang character na may some sort of connection sa kanya, dinilit na rin nila. Pero, yung gusto ni Enrile, talagang hindi mapalabas or hindi ma-produce yung pelikula. Kasi violation nga ng kanyang right to privacy. Naku, sabi naman syempre nung mga producers, teka, hindi naman ito tungkol sa'yo. Huwag kang masyadong pa-big time dyan. This is about a historical event. And your privacy will not be infringed because it's not clearly about your family. And second, yung other part of it, this would be prior restraint on the right to free expression. Nagkaroon ng mga injunctions. So, kumbaga natalo yung Air Productions sa lower courts, which is why these two competing positions went to the Supreme Court. So, sinong tama? In this case, the Supreme Court sided with the producers of the film, and obviously, we're looking at the film right now. Bakit? First, the court stressed that the freedom of speech and expression includes the freedom to film and produce motion pictures. And to show this, of course. Hindi lang yung radio, TV, print ang may karapatan na yan. Motion pictures din ay paraan or medium of mass communication para mag-inform, mag-educate, and mag-entertain ng tao. Huwag na nating pansinin, okay? Ito yung isang point na contentious, no? Sabi ng court, no? Huwag na nating pansinin yung distinction pa between what is knowledge or kumbaga, what is entertainment and what is educational. So, if we make that distinction, it would diminish the basic right to free expression. Now, as to the right of publicity, the right of privacy, sabi naman ng court, well, meron naman ng mga tao na right to privacy, which would be the right to be free from unwarranted publicity from the wrongful publicizing of private affairs and activities of an individual. These would be within the realm of legitimate um, private life and outside of public concern. Kaso dito, it would appear to be a public concern. Okay? Remember that Enrile had a significant role in the um, in the EDSA revolution. Hindi mo mabubura yung itsura niya or hindi mo mabubura yung pag-mention sa kanya in some way or another during this film. The court also pointed out that the injunctions, yung pagpapatigil ng production, is a prior and direct restraint on the exercise of speech and of expression. Malinaw naman yun, ano? Tumigil ang ang shooting. Later on, we will talk about the public figure doctrine. Okay? Kasi dito na papasok ang konsepto ng bakit yung mga gustong mag-public lesser yung expectation of privacy nila. Bakit pwede mo silang picturean? Bakit pwede mo silang ipaparazzi, etc. There is a difference between us and those public figures. And so it is clear that all forms of media are entitled to broad protections. This was also held in the case of Eastern Broadcasting versus Dance. This case involved the closure of of radio station DYRE, which was operated by Eastern Broadcasting. Itong radyo na to, pinasara nung panahon ng martial law on the allegation that the radio station was used to incite people to sedition. Okay? Na mag-aklas laban sa gobyerno. Ang reklamo ng Eastern Broadcasting, wala man lang hearing para totoong alamin kung meron ba talagang anong statements or anong inere nila na incited people to sedition. Tapos wala ding a prior notice, hindi man lang sinabihan na meron na palang reklamo, kumbaga, against them for na may inciting to may seditious statements sila or inere. Bigla na lang pinasara, kumbaga ganun. Tapos, nung nagreklamo sila, nung nag-apela sila nitong pagpapasara, hindi man lang sila in-entertain. Okay. So, umakyat to ng Supreme Court on those questions, both procedural and substantial issues. Substantial being, this is direct infringement of the right to freedom of speech. Both on the grounds of yung kung anong statement, so inciting to sedition. Kailangan alamin kung totoo bang inciting to sedition ba to, or sabi kasi ng Eastern Broadcasting, sa totoo, hindi talaga dahil ang ginawa lang namin, nag-shift kami towards coverage of public events. So, sa public affairs, mababanggit mo talaga kung anong sinasabi ng mga tao. So, hindi namin kasalanan kasi that's the public sentiment at that time. And of course, the other aspect is that the closure of the radio station. On the second aspect, na moot, kumbaga na walang kwenta na yung petition because the radio station was sold to a certain Manuel Pastrana, which would appear to be a crony. And so, wala na, tapos na yung issue ng closure. Kaya masaya na, kumbaga, ang may-ari. Nevertheless, the Supreme Court said that we will still rule on the substantial issues so that there will be guidance for other courts as well. I would have to look into this deeper, pero as would seem, there are no or very few cases that would involve closure of media organizations during martial law because of course, at the time of the closure, klaro na dehado sila. And second, kung ano man, baka nabenta na sa iba. Kaya, ang hirap nang magreklamo kasi nabenta na o nabayaran ka ng 100,000 o kung magkano man. Of course, ano yun, dehadong-dehado yung totoong may-ari. And then also, yung mga may-ari, posibleng nag-asylum na, umalis na sa bansa. So, wala nang point. So, nevertheless, kaya sabi ng court, we'll take this case, Eastern Broadcasting, as an opportunity to decide on specific issues or matters at hand. First, again, all forms of media are entitled to protection. But then, how do you test the limits on freedom of expression? We test it according to the clear and present danger rule, which means that when the words or the expression are used in such circumstances and are of such nature as to create a clear and present danger, which will bring about the substantive evils, then it has to be limited. It has to be curtailed. Okay? Another point. The court pointed out that broadcasting is licensed. No? The airwaves have to be allocated. Airwave frequencies have to be allocated. And who allocates it? It's the government. And lastly, ito, broadcast media, which involves TV, radio, is on a different level than print media. First, it has a uniquely pervasive presence. Kapag binroadcast yan, lahat ng may mata makakakita o makakarinig, lahat ng may tenga. Bata, matanda, kahit na sino pa yan. Hindi mo pwedeng, sarado nyo muna mga tenga nyo, ha? Hindi pwede, di ba? Kaya, kumpara sa print media, which you can screen, yung hindi marunong magbasa, di hindi mababasa. Yung ayaw magbasa, di hindi niya mababasa. Kakaiba talaga yung impact ng broadcast. Second, the immediacy of broadcast media is clear. Kapag kaka-broadcast mo lang at sinabing, mamaya pong alas 10, magkita po tayo sa ganito, maaabot yan, mapapasabi, at machichismis pa sa kapitbahay. Compared sa print, na if you did not read the call to assemble at 10 a.m., you won't be there. Immediate at, kumbaga, instant ang effect or impact ng broadcast media. Kaya, kailangang pag-ingatan lahat ng babanggitin dyan. Compared to print, again, there is no editor right away, di ba? So, kung anong naibuladas mo, yun na yun. Hindi mo na mababawi, hindi mo na ma-edit, at sa panahon nga ngayon, hindi mo na mabubura. Kasi na-on air na, sorry na lang. Ang problema dyan, kapag may sinabi ka na problematic, wala na, it's out there. Ang magiging solusyon mo na lang, paparusahan mo after. Pero hindi or mahirap ang prior restraint sa broadcast media. On the other hand naman, it is important that people can participate or in public debates or comment on public affairs. And broadcast media is a good means to do that. Kaya, at the same time that the freedom of broadcast media is lesser in scope, broadcast media also deserves special protections. Kaya iba ang trato natin sa TV and even TV, movie pictures and radio. Okay? May special considerations lang. Pero at the same time, again, protected all the same. And because we're talking about the tests, there are 3 tests or 3 major criteria that have been applied in the Philippines for allowable punishment of expression. Okay? First, the dangerous tendency test. Second, the clear and present danger test. And third, the balancing of interests test. Okay. Before we go further into this, let's backtrack. We've finished the discussion on Where are we? On prior restraint. So, yung pinasara, pag tumigil ng printing, etc. out. Now, let's talk about subsequent punishment. The case we have for subsequent punishment is about a government official who discussed with, well, fellow citizens. Sorry. Who came to a heated discussion about public affairs. Okay. Ano na to? Sinaunang panahon, 1922. The discussion resulted in him, the public official, si Isaac Perez. So, siya yung akusado dito. It resulted in him shouting several times in different versions, kumbaga. The Filipinos, like myself, must use bolos for cutting off Wood's head. Wood is the Governor General at that time, panahon ng Amerikano, for having recommended a bad thing for the Filipinos, for he has killed our independence. In this case, what's important to point out is that he was subsequently punished. So he made that speech. I know that he's not a publisher, kumbaga, he's not a media man per se. But what's important to point out here is his liability for words uttered. During the trial, he tried to take back his words and explain it. Sabi niya na parang, actually, hindi ko naman sinabing patayin siya. Sabi ko lang, the Filipinos must use bolos for cutting off Wood's head. Ano yun? Figurative yun. Hindi ko sinabing, go, patayin na natin siya, sugurin. Ang ano ko, actually, figurative yun ang gusto ko nga sabihin, patalsikin sa pwesto, si Wood. Okay? It's not violent per se. To relate to current events, I would say it's a reasoning similar to what Lorraine Badoy is now saying. She made statements against a judge. So if I kill this judge, figurative and hyperbole, etc., etc., etc. Now she's saying that she's trying to clarify. No, I did not want to kill the judge. I just wanted, it's not real. Kumbaga, it's just imagined. Nevertheless, in this case, actually, the question in this case was, umakyat to sa Supreme Court kasi na-convict siya. Umakyat to sa court kasi ang issue, should he be charged for libel? Libel being a defamatory imputation or for something else. The court here said, actually, not for libel, so you can be subsequently punished, but not for libel, for sedition. In this case, remember that the words were uttered, or the person who was being referred to was the Governor General of the Philippines. Of the Philippines, appointed by the President of the United States, and therefore the representative of executive civil authority in the Philippines, and of sovereign power. Siya ang pinakamataas na government official sa Pilipinas. So an attack on him is an attack on the rights of the Filipino people and on American sovereignty. So, the case against him, or the charge against him, must be sedition. He tended to stir up the people against the lawful authorities. He made a statement which tended to disturb the peace of the community and the safety or order of the government. In this case, the test that was applied was the dangerous tendency test. And so we go back to our tests. So, paano mo nga ba titingnan yung mga statements or expression as against the purpose of the regulation? Okay? In the dangerous tendency test, ang titingnan dyan, ano yung possibility or tendency na mangyari yung masama. Ganun lang. As in, mukha bang mangyayari ito o hindi? The mere tendency is enough. It's not necessary that the evil was created or it really happened. which is why it's highly unacceptable. The clear and present danger test is one level up. So it now is a more libertarian application. Dito, when the words are clearly dangerous, so makikita mo na talagang delikado to, nagmapagbanta. And more importantly, yung test for present, it refers to a time element. So, it must not only be probable, posible to, but also it must be very likely inevitable, mangyayari. Okay? That's on the opposite end of the spectrum. So, dangerous tendency test, you have authority saying, yes, this is dangerous. This tends to be evil. On the other hand, you have the libertarian end of the spectrum, which says, hindi naman to dangerous, hindi naman to at this point kumbaga hindi siya kumbaga present, hindi kaagad-agad na mangyayari. So at one point there had to be a middle ground, kumbaga a balancing of interests test, which is just essentially a case-to-case basis. So first you would look at the regulation. Ano or paano nililimit yung speech. You compare it with the evil that is sought to be prevented. And doon mo makikita, kumbaga commensurate ba? One of the examples where this was applied was in the case of Gonzalez versus Comelec, one of the cases that was earlier cited. Let's not discuss it because we'll go into the details. But in this case, they use the balancing of interests tests. Dito, sige na nga, a little bit. So, first, yung nominations sa COMELEC, no? So, sabi ng COMELEC, let's regulate the period of nominations dito sa mga political parties. Hindi pwedeng masyadong maaga. Okay? Masyadong maaga, magiging politicking na yan. And then second, nililimit yung period for partisan political activity, which is essentially campaigning. The court here held that, so kung balancing of interests, on one hand, you have your candidates, you have your political parties expressing their exercising their freedom to speech and expression. And on the other hand, you have political, yung integrity of political process. Kailangan mong masaayos yung pagsasagawaan ng elections. Baka may madaya o baka may maging dehado dito sa sistemang to. Kaya, in balancing the interests, ang sabi ng Supreme Court dito sa kaso na to ay, sabi, mangingibabaw ang freedom of expression. Ang mangyayari kasi, if you limit the period of campaigning, also yung too early nomination, meron kang tatamaan na speech aspect. Kasi mag-explain sila ng platform nila, mga kampanya sila essentially. And by clamping down on that, you are overreaching dun sa evil na you seek to prevent. Ang evil na sinisik mo to prevent ay yung may madehado, etc. Masyadong mabigat yung gini-give up mo na right to free speech and expression kumpara dun sa mabe-benefit or dun sa sinasawata mo. Kaya, in this case, sabi, there could have been a narrowly drawn statute. Pwede mong sabihin na kung sa period man lang, no campaigning before this time. O kaya, you are not considered a candidate of this time, etc. The balancing of interests test was actually applied in the dissent. Hindi siya doon sa main opinion. The main opinion used the dangerous tendency and the clear and present danger test. So, may point din nga naman kapag isipin mo, paano naman kung sa balancing of interests, kailangan mo pa rin isipin kung papaano ang epekto nito sa ating political electoral processes. Now, let's talk about symbolic speech. Again, it is speech. Even if it is conduct, ginawa, o kaya, actually, you can say it's expression actually. Hindi man siya sinabi o kaya isinulat, mahihinuha mo kung ano yung ibig sabihin. One example, color coding. Panahon ng Valentine's Day. Wear red if you're taken, wear green if you're looking, wear black kung nagluluksa ka. When you show up in a particular color, then you would know. Elections, you show up in red, you show up in pink, you show up in green, you show up in blue. There's a translation into what you mean. And then lalo na kapag may symbol or may drawing or kumbaga may demonstration na, no? Hindi na lang basta kulay. And this is where different forms of expression can be kumbaga seen as paano sila malilimit because there is a conduct aspect of the speech. Let's have the video for US O'Brien so that you can perhaps better understand it, no?
To the Vietnam War protesters of the 1960s, draft card burning was an act of symbolic resistance. This symbolic act made its way to the Supreme Court in the seminal case of United States versus O'Brien. The Selective Service Administration issued draft cards to each person who registered for the draft. The cards contained information regarding registration status, eligibility for service, and other information that helped the government track registrants. Congress enacted a federal statute in 1965 that prohibited the knowing destruction or mutilation of draft cards. One protester, David O'Brien, burned his draft card on the steps of a courthouse in protest of the Vietnam War. The United States prosecuted O'Brien in federal court for violating the statute. O'Brien argued that the statute imposed an unconstitutional limit on free speech, but the jury convicted him. The Court of Appeals held that the statute violated the First Amendment. The appellate court upheld the conviction, reasoning that O'Brien had violated a different section of the statute prohibiting the failure to possess draft cards. The United States Supreme Court granted certiorari. The First Amendment protects free speech, including expressive conduct. But does it shield someone burning the American flag in protest? In Texas versus Johnson, the United States Supreme Court answered that question. In 1984, Gregory Lee Johnson participated in a protest of the Republican National Convention. Outside the Dallas City Hall, Johnson doused an American flag with kerosene and set it on fire. As the flag burned, protesters chanted, quote, "America, the red, white, and blue, we spit on you," unquote. Johnson was charged with desecration of a venerated object under Texas law. The trial court convicted Johnson, fining him $2,000 and sentencing him to 1 year in prison. The Court of Appeals for the 5th District of Texas affirmed. However, the Texas Court of Criminal Appeals reversed, concluding that Johnson's punishment violated the First Amendment. The United States Supreme Court accepted the case to determine whether states could criminalize burning the American flag. The court concluded that flag burning is expressive conduct protected by the First Amendment. As a result, state laws criminalizing flag burning were content-based speech restrictions that didn't survive constitutional scrutiny. Writing for a 5-justice majority, Justice Brennan concluded that the First Amendment protected flag burning because it contained a sufficient level of communication. By burning the flag, Johnson intended to convey a particular message, and it was likely that anyone who witnessed his conduct would understand that message. For First Amendment purposes, the government has more leeway in regulating expressive conduct than it does in regulating written or spoken words. When speech and non-speech elements are combined in a single course of conduct, a sufficiently important governmental interest in regulating the non-speech element can justify an incidental limitation on First Amendment freedoms. To qualify for this more lenient standard, the state has to assert an interest unrelated to the suppression of expression. Texas asserted 2 possible interests to justify Johnson's punishment. First, flag burning caused breaches of the peace. Second, Texas wanted to preserve the flag as a symbol of national unity. The first interest wasn't implicated in Johnson's case. Texas admitted that no actual breach of the peace occurred. The second interest was directly related to Johnson's political message and therefore didn't qualify for the more lenient standard. Because the restriction on Johnson's speech was content-based, the court subjected Texas's asserted interest to the most exacting constitutional scrutiny. Under that scrutiny, the state's interest in preserving the flag as a symbol of national unity didn't justify Johnson's punishment. The court didn't object to Texas's goal, only its means. Preserving the flag as a symbol of national unity was a legitimate state interest that could support laws regulating how the flag may be displayed. But it couldn't justify criminal punishment for burning the flag. The ideal way to preserve the flag's special role in society was not by punishing those who express contrary views, but by attempting to persuade them with further dialogue. Therefore, the court affirmed the judgment of the Texas Court of Criminal Appeals, holding that the First Amendment barred criminal punishment for burning the American flag in protest. Justice Kennedy concurred, opining that while he found flag burning distasteful, the facts and applicable law compelled the majority's result. Chief Justice Rehnquist, joined by Justices White and O'Connor, dissented. Rehnquist argued that Johnson had many ways of making his point and that Texas law criminalized just one of them. Johnson remained free to express his viewpoint in a myriad of ways. For Rehnquist, flag burning was a form of fighting words, which is speech that inflicts direct injury or incites an immediate breach of the peace. Any expressive benefit derived from flag burning was clearly outweighed by the public interest in maintaining peace and order. Rehnquist also pointed out that 48 states and the federal government agreed with this reasoning, as they had statutes prohibiting flag burning on their books too. Justice Stevens also dissented, reasoning that Johnson wasn't prosecuted for his message, but for the method he used to convey it. Permitting flag burning tarnishes the flag's value. In contrast, criminalizing flag burning was only a trivial burden on free speech, particularly in light of the many alternative methods one has for communicating political ideas. Texas remains a source of deep disagreement. In 2006, Congress tried to amend the Constitution to prohibit flag burning and fell short by only 1 vote.
Do we have sound? Yeah? Okay. So let's go to the Philippines. Do we also have a flag law? Do we have prohibitions on the use and display of the flag? Definitely yes. And same as in the United States, you cannot burn or mutilate or damage the flag. You cannot add text, pictures, designs, marks on the flag or any image of the flag. So, pwede mo ba siyang ilagay sa mug? No, don't do that. Can you wear the flag on your clothing? No. So, panahon ng mga beauty pageant, diba, gagawing costume yung flag, you cannot do that, but maybe you can take a few elements, katulad ng sun and stars na earrings ni Catriona. Meron ding prohibition dun sa painting the flag on handkerchiefs, napkins, cushions, etc. Yung pangbasahan o kaya uupuan. So, hindi rin pwede yun. Hindi rin ito pwedeng ilagay sa brand or business labels. Okay? Yung label, yung naka-trademark or sa label, sa tatak mismo, no? Hindi mo rin pwedeng ilagay sa business card or calling card. Okay? Ito medyo peculiar, no? If you're going to hang the flag on the wall, okay? On the wall, you cannot hang it above. You cannot hang it below anything else. Dapat siya yung nasa taas. So, kung lalagay mo sa orasan, painting, dapat nasa taas siya. And you cannot hang it horizontally, yung pababa, nandito yung sun and stars. Dapat vertically. Tama pala, no? You have to hang it vertically. At alam nyo naman na blue kapag peacetime, red kung wartime. So, yun yung ano. And then, this is important. So, when the flag is up or, ano tawag doon? It's up or displayed, it means that Filipinos or Philippine jurisdiction or authority or sovereignty is present. So, to be technical about it, you cannot display the flag in front of a building or an office that is occupied by foreigners. So, siguro ang punto dito, para hindi nila nakahandle yung Philippine flag, which is an expression of our sovereignty. So, yun yung isang curious thing. Now, I'd just like to go back. It seems we had a problem with the audio earlier. During the short break that was not intended, I was discussing the case of Tinker versus Des Moines. And so we repeat it again, perhaps. Sorry, in fact, I repeated this video because there was no audio in some parts of the previous discussion pala. Alright, so in Tinker versus Des Moines, this is more crucial or more perhaps applicable to you because it involves students, okay? As in the case of O'Brien, this also involved another U.S. war, rather, and this is the Vietnam War again. Here, public school students protested the U.S. war, of course with the blessing of their parents, by wearing black armbands when they went to class. So, of those students who were suspended, 3 they were suspended by the school administration. And so they went to court. Sabi nila, hindi pwede ito on 2 points. First point is that, paano kami na suspend kami sa walang kakwenta-kwentang dahilan or unreasonable na dahilan. And then second, the regulation, because the school also prohibited the wearing of armbands. The regulation is unconstitutional, so it should be stopped. There should be issued an injunction. So, nung pumunta sila sa korte nung unang-una, mas nanaig yung authority ng school administration to regulate conduct or to discipline the students. And so also with the Court of Appeals, although divided yung Court of Appeals, they needed to go or they had to go to the Supreme Court to secure a positive ruling. Okay? In the Supreme Court, first it was held that ano ba yung nature of the wearing of armbands? It's speech, even if it is conduct. And in the exercise of that speech, of their freedom, they were not disruptive. They did not impinge upon the rights of others. They were not um, what's this? They were not too noisy. They were quiet. In fact, they were passive. Tatayo ka lang doon, maglalakad ka, tapos may armband. And therefore, the conduct was within the protection of the free speech clause. Okay. Also, pag-usapan natin yung teacher at students. Dito na nakalagay ang all too important phrase, students do not shed their constitutional rights at the school gate. So you as students, as long as you're in school, or as in this case, you are expected to be in school, you are still exercising your constitutional rights. At any violation of that rights, you could ask for action. Okay. And then lastly, so paano na ito? Kapag merong prohibition, di ba, syempre, meron naman po sigurong pwedeng ma-regulate. For example, a rally or any noisy activity that would interfere with class. Or sa mismong klase, kung bigla lang may isa sa inyo tumayo dito at nag-discuss ng tungkol sa karapatan ng mammals, dolphins, whales, or karapatan ng marine animals, ganyan. And buong klase nagrally. That would be disruptive of the time that is allocated for us to be learning. Hindi ba po pwedeng ma-regulate yun? Actually, there could be times when conduct can be regulated, especially in the school. But if you're going to regulate it, the rules should be necessary to avoid substantial interference with school discipline or the rights of others. Okay? Yun lang yung tatamaan. As we earlier mentioned about the balancing of interests, there would be two competing rights or two competing interests. You just have to weigh which is which. In this case, you really have to show, as in the school premises, that there is no interference with school discipline because the school clearly has the right to discipline us, not only you students, but likewise us as teachers. And so we end on this note on protected speech. And at the next meeting, we will be discussing how right to free speech not only clashes, no, pero relates with other forms or exercises of other rights. Okay, so I'll see you then, and happy weekend.